Hello, good afternoon to some and good morning to others. My name's Joel Gordon, and we're here for another session of Global Law Experts LinkedIn Live, where the world's leading lawyers take the topic everyone is talking about and make it make sense. One expert, one topic, 30 minutes. Now, I'm not a lawyer, which means I'm going to answer the questions you actually want answered. So today, that expert is Amir Gokhale of Shardal Amchanda Mandalas, one of India's leading law firms. Amir advises foreign parties on international arbitration and on the one clause that decides how every India-related dispute plays out, where you sit it. Amir, welcome. Really glad to have you with us here today.
Thank you, Joel. Thank you for the opportunity to interact with everybody. I look forward to the next 30 minutes.
Amazing, amazing. So here is why we are discussing this now. So foreign investment into India just hit $94.5 billion, up 17% year on year. The money is flowing in, and India is pushing hard to become Asia's arbitration hub. New institutions, a draft bill to reform the arbitration.
Joel, I think you need to look at your audio. I can't hear you.
Oh, is the audio not working? My apologies, Amir. Let me just double check. I can hear you fine. Let me just make sure. Is that better?
Joel?
I can hear you.
Sorry, your audio.
Let me double check to see. Can you look in the chat? I can hear you. Technical difficulties. Let's see. Can you hear me now? Is that okay? Is that better? I can hear your side, sir.
No, I can't. I still can't hear you.
Not at all. Maybe check the audio on your side. How about now? Is that better? I think your audio is working fine. Maybe if we... Can you hear me now? Let me know if the audio starts working again. Maybe if you leave and rejoin, that might work. Is that better?
Battery low.
Low battery.
No, I got you now. Yeah, I can hear you now.
Okay. Perfect.
Sorry, I tried moving to another speaker, but I think the original one is working. Yeah, all right.
No, it's okay. It's okay. I think there's a bit of an echo. How can I resolve? Is my audio coming
Is it gone
through
now?
Yes.
Yes, you're quite clear.
Amazing. Okay, so back to the presentation. As we were stating, the reason that we are talking about this now is because of the surging influx of foreign direct investment, up 17% year on year for the past couple of years. India is pushing hard to become Asia's arbitration hub, as mentioned, but at the same time, there's a live debate about trust and protectionism, and the real argument about whether you should ever seat an India-related contract in India or just default to Singapore. So the clause it all comes down to one line in the contract that matters the most, but people treat it as a boilerplate, the seat of the arbitration. It's not just where the hearings happen, it decides which court supervises the arbitration, which law governs it, who you go to for emergency relief, and whether your award gets enforced or set aside. Get it wrong and you find out at the worst possible moment. So for the next half hour, we'll be discussing these four things. Why the seat matters so much and what goes wrong when it's an afterthought. How Amir weighs an Indian seat against Singapore or London. Where India genuinely holds up in 2026 and where he'd still steer you towards Singapore. And what actually happens once a dispute hits, interim relief, the courts and enforcement. And in the last 10 minutes, we'll take some questions. So you guys feel free to drop any questions in the comments as we continue. So that's what we'll be covering. So I'm going to start with the foundation here. So question one that we've seen, the seat fixes the supervisory court and the law of the arbitration, but it is so often treated as a boilerplate as mentioned. For a party contracting with an Indian company, why does getting it right matter so much, and what goes wrong when it's an afterthought?
Right. So, Joel, it's an existential question in the Indian legal market today. You're right. There is a tendency when most contracts are drafted to use, boilerplate contracts, boilerplate clauses, arbitration clauses, and that's where the problem really lies, right? Because arbitration as an agreement is a completely separate agreement, and you need to treat it as a separate agreement. It's not so much as a matter of standard. I think there is a lot of strategy that goes into drafting an arbitration clause, and as you've rightly shown, in in the presentation, there are so many consequences that actually come from the arbitration clause itself, right? What we've normally seen, the common mistake that people make when they use boilerplate contracts is that you would normally find that there is no clarity in the clauses, which could lead to confusion when you're actually going through the arbitration. In some cases, we've also seen conflicting clauses where, the boilerplate clause somewhere would say jurisdiction of a particular country applies, but the arbitration clause would have a different seat and a different court which would have jurisdiction over that arbitration. So a lot of the disputes, arise out of this kind of unclear drafting or this kind of conflicting clauses. And what we also see is that when you use boilerplate clauses, there is more often than not confusion between what would be the seat and what would be the venue. Seat, as you have very clearly identified and rightly identified, has a lot of repercussions. For example, which is the jurisdictional court, which is, what kind of law will apply, procedural law that will apply, etc. We see a lot of times when there is a tendency to use boilerplate clauses. Somewhere you miss out on actually specifying what is the seat versus where your arbitration would be held for convenience. So as a corporate lawyer, we always suggest that when you are drafting a particular clause, please do come to the litigation lawyers, please do come to the arbitration experts to actually have a look at your arbitration clauses so that enforcement doesn't become a problem going down the line.
Amazing. So check with the arbitrators as well to make sure that when it does come to enforcement, you're well
Sorry,
prepared.
Joel, I've lost your speaker once again.
The audio is good again. Well, is there anything that you could tweak on your side?
No.
Let me see. Am I back now?
Battery low.
Oh, it seems like we've got a low battery.
Image Mac Mini. Image iPad 129 Pro.
Am I back? You let me know if you can hear me.
Can you hear me?
I can hear you perfect.
I can't hear you. I still can't hear you.
Okay. Well, you tweak around with the speaker, and as soon as it's back on live, then you let me know. Is that better? Still no?
Yeah, can you try again?
Yeah, whenever you're ready. Just let me know as soon as you can hear. Am I here now?
I can hear you on another speaker, but not very clear.
Oh no. All right. Well, how is that? Is that better? I think you've muted your mic now, but I can hear you fine. Let me know if you can hear me. Your mic is on. Yeah. Can you hear me now?
Joel, can you hear me?
Well, hopefully we still get to go through the questions. Apologies for any inconvenience for anybody who's watching at the moment. Yeah, technology is not much we can do about it. Let's just hope that we can get back on live soon. Mr. Emia, as soon as you can hear me, just give me a thumbs up. I hope that, yeah, now you're on mute. So I'm not too sure how things are going to work on your side. Is that better? Hello? Mr. Emia? You can't hear me? I cannot hear you now. Your mic is on mute. Well, that is a bit of a shame. Let me see. Can you hear me?
Okay, let me try to re-log out and try and re-log in if you don't mind.
Yep, no worries at all. Just let me know once you're back. Just join with the same link and it should be fine. Oh, apologies. You know how it is sometimes, these technical difficulties. Let's see if we can get back in. Hopefully, shouldn't be out for too long. Let's go through some of these slides. And so, what was the next question that we had? Indian seat or a Singapore seat was the next question coming up. Then we had, where does India hold up and where it doesn't? And question 4, once the dispute hits, where do we go from there? So hopefully Mr. Emia will be back to answer these. We shall see. We'll give him about 3 minutes and then we might have to reschedule. Hopefully we can get back on. Oh, and it seems Mr. Emia is back. Yes, to the stage.
Yes, is that?
How are we doing?
Yeah,
you can hear me?
I think I can hear you now.
Perfect. No, it's okay. These things happen. I'm just glad that we got it sorted in the end. So we was just rounding up question 1. So what I'll do is I'll jump into question 2 then,
Sure.
Just to give the audience a bit of a reminder. I just went through the questions quickly anyway, so it should be fresh in their minds. So question 2 that we've been seeing, say you're advising a foreign party contracting with an Indian company. When you sit down to choose, how do you weigh an Indian seat against a foreign one like Singapore or London?
So, Joel, there are actually a lot of considerations that would go into selecting, a seat, whether it is an Indian seat or whether it is a seat which is outside the country. Mm-hmm. I think the first and foremost consideration that a lot of parties have is the cost that comes with arbitrating in a jurisdiction outside India. If statistics are to be relied on, then arbitrating in Singapore versus arbitrating in India, the costs could be significantly higher. So, that's a very, very big consideration for a lot of parties. I think the other consideration for a lot of Indian parties, especially, or even foreign parties for that matter, is where are you going to ultimately go for enforcing your interim reliefs? So, for example, if the arbitration is seated in India, then you would have the availability of an Indian court to enforce interim orders, or to, you can ask for interim orders before an Indian court. Typically, what happens is that when you have a foreign party who is going to sue an Indian party, you would advise a client to have the seat in India, because obviously the Indian party would have assets in India, and an interim order would be more enforceable or quickly enforceable in India as opposed to arbitrating in Singapore, where, yes, there is, most of these institutional arbitrations do have provisions for emergency arbitrations, but you have to again get the emergency arbitrators' orders back into India to get it enforced. So there is a separate second layer of separate layer of proceedings for which there would be a considerable amount of time and costs that you would need to spend in order to enforce the interim relief. So that's another very, very big consideration. And ultimately, the enforceability is also quite relevant when you're choosing the seat. And I'll give you an example. A couple of years ago, one of my colleagues asked me. They were negotiating a contract, and he asked me, "Look, we want to have our seat of arbitration in Bangkok." Now, so I asked him, "Who is your client?" So he said, "My client is an Indian party." And I asked him, "Who's likely to breach the contract?" So he said, "My client is likely to breach the contract because my client has obligations to perform. The other party is only going to pay. So if there's a performance issue, then my client is likely to breach that contract." So I said, "Very good. Then you must have Thailand as the seat of arbitration." And the reason I told him that is because a Thai arbitration award is not enforceable in India. So, if there was a party which was to get that award in India to enforce it against his client, they would not be able to enforce that award. It's not a reciprocal territory recognized by the Indian government. So you see, there are strategic questions that you need to consider before deciding seat versus the venue, and cost considerations. I think those are really the two very, very big considerations that I would have while advising a party on whether to arbitrate in India or to arbitrate outside India.
So the main two would be cost and enforceability then.
Exactly. Two of the biggest considerations, I would say.
Amazing. Thank you for sharing. So what I'll do, I'll get into question 3 then. So question 3 that we've seen come through the platform, and where India holds up and where it doesn't. So India is pushing hard to become Asia's arbitration hub, but the commentary right now says investors' trust and perfectionism are holding it back in 2026. So where does an India seat genuinely hold up, and when would you steer a client elsewhere? You mentioned the case in the past, but is there any kind of clear guidelines that you normally go by?
Yeah, I think that's a good question. India's been grappling with making the country a very attractive venue for holding arbitrations. And I think, the reason why Singapore, for example, or even London have become very, very popular is one, because, there is some level of the trust really that people have comes from two things. One is the professionalism with which they run the arbitrations. That's number one. Number two, that there are some strict timelines that are followed, and which means that that the arbitration is going to end within X amount of time period. And number three, that you will get very, very responsible arbitrators, because in most institutional arbitrations, for example, the SISC, they have a very robust review process of how the arbitrator has performed. I think these are the three very, very big reasons why Singapore or London have become very, very popular as arbitration venues. Now, what we've done in India in the recent past is, a couple of things. The Arbitration Act in India has been amended at least about 3 times in the past decade. So we had an amendment in 2015, in 19, and more recently in 24. The thrust of these amendments was one, to give a lot of emphasis to institutional arbitration. So we've had the rise of institutions such as the Mumbai International Commercial Arbitration Center, the Delhi International Commercial Arbitration Center, which in the past, I would say half a decade, have performed extremely well as arbitration governing institutions. There is a level of accountability that is attached to the arbitrators. The panel of arbitrators have, they've got some very, very competent and extremely good arbitrators which are sitting on the panel of these arbitration venues, arbitration centers. So you've got accountability, which is being covered quite well. And then the Arbitration Act itself has, a lot of very important amendments where we now have a timeline of 12 months within which the arbitration must finish. That can be extendable by another 6 months plus 6 months with the consent of the parties and then by an application to the court. But in short, the timelines to finish arbitration are now very, very clearly defined. So a party getting into an arbitration knows that that he or she will get an award within at least about, on an average, about a year and a half. So in terms of just timelines, I think foreign investors need not be worried about how the arbitration itself will go. The only point where we are lacking and the only issue where we are lacking is still enforcement of the awards. And while now the courts are very, very conscious of not interfering in arbitration awards and enforcing arbitration awards unless and until there is something fundamentally wrong with those awards. We've also seen that enforcement of awards has actually, the rate of enforcement and timeline for enforcement has improved quite a bit. So therefore, in the coming future, I do see India being positioned very, very well as an arbitration venue. I do see that, foreign investors reposing more trust and more faith in the process. And I have a lot of hope for the way arbitrations will be conducted in this country in the next decade.
So it really is the enforcement that was the only side that was lagging at the moment. But you think that moving forward, there should be great improvements in the area, and soon that won't even be a thing anymore.
That's correct. That's correct.
I see. Well, I'm sure the foreign investors and people caught up in these scenarios will be more than happy to hear that that is ironing itself out.
I hope so.
So we're going to get into the next question that we had now. So question 4. The last one that we had before we go to the questions in the comments. So once a dispute actually hits, the seat drives interim relief, court intervention, and enforcement. So for a foreign party, what are the real consequences and what do clients most often overlook?
Right. So, as I said, once the dispute hits and once you have an award, what happens with the enforcement? So far, we've been seeing that traditionally judges would treat an application to challenge the award almost like an appeal. So all kinds of grounds would be introduced and appeals would be heard for not many months but many years. So enforcement would get stuck for many years, virtually rendering an arbitration award unenforceable for quite some time. What has happened now is that courts have relooked at a lot of these precedents, and the jurisprudence where we stand today in this country is that at the challenge stage, there are only very, very narrow grounds of challenge. The legislation has made it very, very tough to challenge an arbitral award and to get that arbitral award set aside. So we are seeing that there is more emphasis on enforcement. Courts do not entertain frivolous pleas which will stop the enforcement of an arbitration award. In many cases, if parties are actually sitting on an arbitration award and a challenge is pending in court, the court will require you to actually deposit a significant amount of money, which could be anywhere between 50% to even 100% of the award value in court, before execution of that award is stayed pending the appeal or pending the challenge. What then happens is that if a party is already going to be out of pocket pending the challenge to the award, the incentive to challenge an award on frivolous grounds then goes down. So this is one of the biggest, changes that we've seen in Indian courts, where they have now become pro-enforcement. Time taken for enforcement has come down considerably. You could get enforcement, perhaps, your petitions for challenging the award would be disposed of perhaps within a year or so, less than a year, I would say, in some cases. And therefore, foreign investors, derive value out of the process, because The arbitration finishes quickly, enforcement is quick, enforcement grounds, the challenge grounds are very, very narrow. And therefore, I think, once the foreign investors actually look at this process, I think there will be a lot of confidence in the way arbitrations are enforced or arbitral awards are enforced in India now.
Mm-hmm, mm-hmm. How do you think India is going about making sure that foreign investors are aware of the changes?
I see a lot of the Indian lawyers, Indian parties interact quite a bit with foreign investors in the backdrop of a lot of the institutional arbitration frameworks. At the government level, I think there has been a massive amount of push to improve legal processes that will make India friendly to foreign investors. Thereby meaning that not just arbitral awards, but even court decisions are enforced extremely quickly. There has been great amount of outreach to foreign investors at the government level and at the private level, which is a lawyer-to-lawyer exchange and a government-to-government exchange. So I think efforts are being made at a very, very large scale to make sure that the foreign investors are aware that now India is changing on these processes also.
That's good. That's good, because making all these changes, it's great to just know that people are actually paying attention or being informed of this to get that stigma out of the way.
Correct.
If you could write one line into every India-related contract, one line to spare a foreign client the worst of these surprises, what would it say?
Look, I mean, that's a very difficult question, to be honest, because it would really require one to know what is it that a foreign client wants primarily in his arbitration agreement, right? If I have to stick to just arbitrations as such. For example, if a foreign client does not want an Indian court to interfere in the arbitration process, even at the interim relief stage, then the Indian law requires that there be a specific exclusion of Indian courts. So, in a situation like this, I would tell the client that, look, don't leave this into the realm of possibility or impossibility. Please specify the exclusion very, very clearly in your clause. So it depends on what really a client wants. The underlying necessity is that whatever you write in your agreement must be clear and must show the intention of the parties very, very clearly. There can never be a doubt in the language of the contract as to what the parties really meant. So that would be my advice to a client.
Just super clear, make sure everything is labeled and as such.
Exactly.
Okay. What I'll do then is I'll just go to the comments. As there hasn't been any questions so far, there were a few other questions that we had seen had been asked. So I'll ask a few and we'll see if some questions come in as we continue. Sure. So one of the questions that we had, again, seat versus venue, it seems like this is a very hot topic. People use them interchangeably, but they are not the same thing. So what's the practical difference and why should a contract never leave it unclear?
Yeah. I think it's a very important question. Honestly, in an arbitration clause, venue is not even something which is required to be written, right? Because venue is only a place where you would want to conduct an arbitration hearing only for the sake of convenience. So really, venue is not a concept as far as strictly a concept as far as arbitration is concerned. In that sense, seat is a very important concept because the seat would determine, for example, which would be the jurisdictional court. If the procedural laws are not clearly explained in the contract, then the seat would be a very, very important aspect to be taken into account while determining what is the procedural law, what is the curial law, which is applicable for the purposes of the arbitration. So the seat really defines a lot of very, very important things. It is consequential to a lot of very, very important things. And which is why, going back to my earlier answer, it is so important for you as a client to mention very, very clearly what is the seat that you would want to apply to your arbitration agreement. Now, in India, we have a very interesting concept. The Indian law, the Indian Arbitration Conciliation Act, actually doesn't use the word seat at all. The word that the Indian Act uses is place of the arbitration. So we've had controversy in the past as to, is the place the seat or is the place the venue? So the Indian Supreme Court had to come out and clarify this in one of its judgments, where now the law is settled that the place equals to venue. Place equals to the seat. So seat and place are the same thing, and venue remains a concept that the parties will only want to discuss for holding a hearing for as a matter of convenience, nothing more than that.
Okay. So it sounds like venue is a very minor detail. Why is it even included in the conversation?
Exactly, and I would frankly advise clients, and in a couple of cases we have advised clients, not to actually mention the venue at all in the arbitration clauses, because the minute you'll end up mentioning seat and venue or place and venue, you would then give a foot in the door to another party to actually argue that the clause itself is not very clear. A lot of times when clients ask, that there is a seat mentioned, can we hold the sitting of the arbitration in a different place? My advice would be that yes, if the party agrees, the other side party agrees to it, then you can always have the hearing in another place. That will have no difference or no bearing on the seat itself. But that's just a matter of convenience.
I see. So realistically, the misconception is that venue actually has to be mentioned at all. Realistically, it doesn't actually have to be mentioned, and it's actually in your benefit to not mention it because that allows for flexibility moving forward.
Exactly. That's right.
Amazing. Well, that's definitely one for the people watching that they'll definitely be interested in. Now, the second question that we've seen, can an India seat award be challenged in court, and how often does that delay enforcement?
India seat award being challenged in a foreign court?
Yeah, so the question that we had, so actually we haven't specified whether it be a foreign court or not. The question that we had was, can an India seat award be challenged in court, and how often does that delay the enforcement? Right. But feel free to explain the difference between a foreign court and one in India.
Sure. So yes, an India seat award, which would then be termed as a domestic award in the Indian Arbitration and Conciliation Act, can certainly be challenged. And there would be three real rounds of challenges for that award. So one challenge would be in the form of what we call as a Section 34 challenge, which is a very, very limited challenge on very, very limited grounds. So there are grounds of public policy, or there are grounds of jurisdiction, which are very, very limited and defined, under which you can challenge the award. But what also happens is that the judgment of a court in a Section 34 application, there is also an appeal which is available to the losing party. Mm-hmm. So that would be the second stage of, in that sense, appellate proceedings in relation to an arbitral award. And then there is a third possible challenge before the Supreme Court of India to a order that is passed in the Section 37, which is the second level, right? Now, typically, what we see is that, in the Section 34, which is the challenge on very, very limited grounds, the trend now is for the courts to dispose of these challenges fairly quickly. If you really don't have an important challenge or a meaty challenge, if it's just a frivolous challenge, most courts don't entertain it. And you would have a disposal to that fairly quickly. And the same can be perhaps said about the next two rounds of appeals also, that if there is no merit, then we don't see that an arbitral award will be pending in these forums for very, very long. The problem that we are seeing currently is that if there is actually a very, very good ground to challenge the arbitral award, then the courts take a little bit of time to consider that challenge, go through the challenge, apply precedent to that challenge, and that's where we are perhaps seeing some delays in actually the award attaining finality. And that's perhaps some difficulty that we have systemically as far as Indian courts are concerned. Looking at the pendency generally in courts, a lot of these arbitration awards get stuck in that process, and that's something that India is actually looking to improve in the coming years. But at the moment, that's where the challenge really lies.
But it seems like India's quite proactive in this area, and that's why you're going to or moving towards being the arbitration hub, because of the proactivity and understanding where things are delaying and actively looking to improve in those areas.
Yes, I would think so. That's correct.
Amazing. So we're being cautious of time here. I wanted to ask one on a bit more about your perspective. So what's the single most common mistake parties make in an India arbitration clause? I think that's something that everybody would like to know.
I think the biggest mistake that people make is having unclear arbitration clauses. It's so important to be particular when you're drafting an arbitration clause. You cannot have anything in that clause that would potentially give a party a ground to say that there was no clarity. There was no clarity whether something was being referred to arbitration, or what was being referred to arbitration, whether a part of that contract was being referred to arbitration, whether the entire contract can be referred to arbitration. And we have many of those clauses, where very, very loose words like may refer, or choices between arbitration and negotiation are given to the parties, where courts would then step in and say, we don't think there is an intention to arbitrate. So I think that's the single biggest mistake that people make, is unclear arbitration clauses.
And looking ahead, where do you see India's arbitration landscape heading over the next few years?
I do hope that institutional arbitrations do become very popular. With experience, there'll be a lot of improvement with what they are doing. They're doing quite well even today. And once institutional arbitration, I think, becomes something that investors, foreign parties can really trust in, I think you will see increasing inbound volumes in this country, and this country will then truly become the arbitration hub.
And I guess that's just with time. As time continues, then they'll gain the trust and we'll move forward as in such, basically.
Correct.
Amazing. Well, that seems like a great place to end. Amir, you shed a lot of light on India's proactivity, and I think that's a misconception that we can throw out the window now. It seems that India is really leading and looking to be the leaders in the arbitration area. But yes, as I stated, that is the 30 minutes done now. We ran slightly over. So, Mr. Amir, thank you. As I said, that was genuinely useful for our viewers. And if anybody wanted to go deeper, you'll find Amir Gokhan's full profile on Global Law Experts. Now, we run these sessions regularly with GLE members across 140 countries. So follow the page and catch the next one next week. Thank you for watching, and we'll see everybody then. Thank you.
Thank you, Joel. Thank you for your time. And I hope this